the lists of things that you could list as force majeure. Now, you might note on reading through it all, I'm not going to read through all of it, but you might know it doesn't include epidemic. So if you are going to use this in the future, I suggest you add in epidemic, just to make sure you're covered in case it comes back next year. Right, thank you very much, everyone. I've taken up a lot of your time and I apologize. One of the things you can do when drafting the contract is include this clause, included but not limited to, and then add in the extra things that you can think of, which would of course include epidemic and all the other things that are specific to your particular geographical region or your particular industry. Right, I'm sorry I've thrown an awful lot of information at you, but I hope you're able to follow me. Thank you very much for listening, everyone.
Thank you, Richard. That was very insightful. So we do have a number of questions that came in as you were speaking. I just want to ask the speakers quickly, shall we take those now just so that we can answer some of those questions and then move on to Cyrille, or shall we wait to the end of Cyrille's discussion?
Let's wait to the end of Cyrille, because I have a feeling we're going to end up with 40 or 50 questions, and we may have to end up writing to everyone at the end of the session. Let's go to Cyrille first, I think, because right. Cyrille may answer some of the questions in what he says, because I know he's going to deal with some aspects of this as well.
Great, we'll do that. So bear with us. I hope you will find the next session, or I'm sure you will find the next part of the session useful. Cyrille, without further ado, I will commence.
Yes, hello everyone. Thank you, Richard. In contrast with the position in the UAE, where there's a civil code in the DIFC, at least in the there's a civil code, and which provides for a clear definition of the concept of force majeure and the conditions that would have to be met for the force majeure to kick in. There is no such clarification in Saudi Arabia, and frankly, one thing that would shock any external observer is that force majeure is not defined by the law of Saudi Arabia. Actually, what we have is references, legal references to the concept of force majeure in various pieces of legislation. For example, in the mining investment law, you have Article 28 that provides that force majeure covers the circumstances which are generally recognized as force majeure events resulting from unforeseen circumstances at the date of issuing the license, which are beyond the control of the parties and which renders the fulfillment by the licensee of its obligations under the license impossible. So here you'll notice that there is a reference but no definition. Another piece of legislation is the Saudi labor law. Sorry, can we move on to the next slide? Hello?
Yes, the next slide again.
Okay. Yes. So again, you have other examples here from the slides. Yes, that's not this one, the previous one, dealing with labor laws, Saudi labor laws.
Okay. Sorry, Cyrille, have I jumped forward too much?
No problem. Just a few examples of how the concept is of force majeure is referred to but not defined. Article 74, for example, of the Saudi labor law, which says that the contract may be terminated in case of force majeure, and that in such a case the employee shall be entitled to a full end of service indemnity. Also, another article from the commercial maritime law, Saudi maritime law, which also refers to force majeure as an excuse for non-performance of contractual obligations, but does not provide a definition of the concept.
Sorry, Cyrille, if I can just stop you for a moment. It doesn't seem to be very clear. And we have some people also commenting in the chat box that they can't hear very well. There seems to be some static.
Yes.
Okay, maybe speak again.
Not really. So we have to get back a little bit. Just to the legal references to the concept of force majeure.
Sorry, Cyrille, sorry, just a moment. I'll go back to, is this the right slide now?
No, this is not the correct slide. Anyway.
No, let's go back to the slides.
No problem. No problem. Yeah.
I'll just go back to the slides. I'll go back to the slide. Cyrille, just tell me which one we should be on now. Is that this one?
Yes, absolutely. So here is also you have examples from the Saudi labor law, Article 74, for example, which I mentioned before. Article 87 as well, which provides that the employee who terminates his employment contract or who has his contract terminated by the employer is entitled to full end of service indemnity. Article 1 of the Public Procurement Law also it's not that it defines, it refers to force majeure as a circumstance in which public safety, security, or health are subject to a serious and unforeseen threat, or in which a breach is likely to result in losses in property and human lives and may not be handled with common procurement rules and provisions. As you can see from these examples, there are several legal references, but no definition of force majeure under Saudi law. So in that case, we could rely on the provision of Sharia law to fill the gap. Can we move on to the next slide, please? The next one, dealing with the theory of Suraya. Yes.
Yeah.
The slide before this one, please. Before this one. So in order to fill the gap, we have to rely on Sharia law concept, which is the concept of jawa'ah, which means in English calamities. So it covers events such as floods, hurricanes, pandemics as well, and this was developed by Islamic scholars. So the general principle in Saudi Arabia that govern contracts is that the contracts must be fulfilled by the believers. يا أيها الذين آمنوا أوفوا بالعقود, which means that the parties to contracts which create reciprocal obligations must fulfill their respective obligations. Of course, there are exceptions to this principle. And one of these exceptions is the theory of jawa'ah, disasters or calamities, as I said, which according to scholars include divine calamities or disasters against which one cannot guard, such as storms, extreme cold and heat, heavy rains, lightnings, floods, earthquakes, tsunamis, endemics, pandemics, foreign armies, invasions, etc. Okay. Now we move to examine the conditions for the theory of jawa'ah to apply. First of all, we'll take a look at the foundation or the basis of the regime of jawa'ah. There is a hadith related by Muslim according to Jabir bin Abdullah, who said that the Prophet, peace be upon him, said, if you sell a fruit to your brother and he is afflicted by a calamity or a disaster, you shall have no right to take anything from him, as how could you fairly take money from him? So Hanafi scholars, and here you have to be mindful that there are 4 schools of thought in Islamic scholarship or doctrine in Saudi Arabia, but the prevailing ones are the Hanbali and then the Hanafi school of thought. So the Hanafi scholars have allowed the termination of the contract on grounds that the calamity has lawfully excused the afflicted party from fulfilling his contractual obligation. The regime of jawa'ih was accepted by all scholars with slight differences from one school to another. Initially, and as the hadith we just mentioned restricted the application of the theory to the sale of fruits, the application of the doctrine was extended to cover almost all contracts placing reciprocal obligations on the parties, and also on contracts that are continuous in nature. Can we move? Yeah, please. So what are the conditions for this doctrine of jawa'ih to kick in and to apply? Here are the conditions for the doctrine to apply. The calamity must have been caused by an external factor beyond the control of the parties to the contract. This is something that is also akin to the definition of an event of force majeure. The calamity must be general and not special in nature. For example, here in the case of the COVID-19 pandemic, it has affected the whole country and not only one region. The consequences and damages resulting from the calamity cannot be prevented or guarded against. This is also something that we find in the common definition of force majeure under the civil law regime. And finally, the contracting party affected by the calamity must not have committed a breach or a negligence that would have compounded the harm resulting from the event, the calamity or ja'iha. In such case, the calamity may not operate as an excuse. Whenever the party that wants to avail itself from ja'iha to excuse the non-performance of his obligations, he should not have committed a breach or a negligence in the fulfillment of his obligations. Can you move to the next slide, please? Okay, now having defined the conditions required for the jawa'ih doctrine to apply, do we consider that the COVID-19 pandemic meet these conditions? We are inclined to think so. As the pandemic meets the aforementioned conditions, this is, an external event, caused by external factors which have nothing to do with any human intervention. At least so far, it hasn't been proven that there was any human intervention that caused the pandemic. Also, the pandemic, the parties could not guard against the consequences of the COVID-19. This is an external and exceptional circumstance affecting their obligations. And we believe, given the conditions of the jawa'ih theory, that the pandemic, COVID-19 pandemic, qualify as ja'iha and could operate as an excuse for the parties to suspend or not perform their contractual obligations. Okay, how could the KSA courts apply the doctrine of jawa'ih on pending contest contracts that have been affected by the pandemic? Of course, the court will seek first to introduce justice, an element of justice in the contracts that have been affected by the pandemic. They will have regard to several factors. First, whether there is a law, a regulation, or a policy or a clause in the contract dealing with this occurrence. Second, whether it affects the whole contract or part of it. Then whether one of the parties contributed to the harm that resulted from the pandemic, whether by his negligence or the breach of the contract, whether there would be another way to implement the contract, and whether there is a way to mitigate the consequences of the pandemic. Now there are two scenarios. Scenario one, there is a force majeure clause in the contract. Then the court, if there is a dispute, the court will uphold the agreement of the parties pursuant to the general principle that contracts must be implemented as per the agreed terms between the parties. Now, if the contract does not contain such a clause, the court shall have regard to the conditions for the application of the doctrine. If these requirements are met, the court is likely to adopt one of the following approaches. The priority, of course, is whenever possible to alleviate the consequences of the calamity through suspending the contract throughout the calamity, providing a respite or a delay for the affected party to perform its obligations. The most important thing, the paramount consideration for a court is to, whenever this is possible, to enable the parties to continue fulfilling their obligation. Now, if the calamity or the jaiha makes it much harder for a party to perform its obligations, whenever such a performance has become impossible, then the court would have no other choice but to terminate the agreement. Okay. Can you please go back a bit? The previous slide, please, Suraya. Okay, so if the calamity, as I was saying, if the calamity makes it harder for a party to fulfill its obligations, the court may take one of the following stances. It may either, and there is a lot of flexibility here and discretion allowed to the court, it may either modify the scope of the contractual rights and obligations. It may also decide that the contract should be terminated because there is no way that the parties could ever fulfill their obligations under the circumstances. It could, as I said, grant a grace period to the contracting party if it believes that the calamity will go away in a short time and the beneficiary of the obligation will not incur a significant damage. As I said, the court has a discretionary power to decide whatever remedy it may deem appropriate under the circumstances. Now, I should say here that sometimes the parties will not need to go to court because the situation has been dealt with by regulatory authority. For example, SAMA lately has issued several decisions. One which is very important for people who have financial and credit commitments, giving them, for example, a respite and suspending their payment obligations for a period of 6 months. So this is important to note because, and I would anticipate that also other relevant authorities in Saudi, for example, the Ministry of Municipalities and Rural Affairs would probably also grant a suspension of rental payment obligations on commercial or residential leases, and this is something we should monitor closely. As far as insurance contracts are concerned, also SAMA, which is the regulatory authority, would also likely intervene to decide what has to be done with the payment of premiums, for example, and the whole economy of the insurance contracts which have been affected by the pandemic. Yes, it's worth noting first that unlike the situation in the UAE, there is no theory of precedence here in Saudi Arabia, so it's very difficult to understand the position regarding a specific matter, how a specific matter has been dealt by the courts, because judgments rendered by court are not binding either on the same court that rendered them, but also on other courts, and therefore a similar case that is being brought in front of different courts will most probably receive different solutions. Also, there is no system of systematic publication and compilation of judgments in Saudi, which makes it very difficult to follow the position on a specific matter. However, there have been some judgments which have been issued by the administrative courts and commercial courts in Saudi Arabia that have dealt with the concept of force majeure, but that have been dealt with in accordance with the principles of Sharia and the doctrine of Jarrah. Can we move on to the next slide, please? Yes, what are the contracts that are most vulnerable to the COVID-19 pandemic? Obviously, all contracts, all continuous contracts that have to be performed over a long period of time will be affected, but definitely the ones that attract the most attention are employment contracts, banking and financing contracts, lease contracts, insurance contracts, travel and shipping contracts. And I will be able to respond to any questions someone in the audience may have regarding how the situation would be dealt, for example, for the lease contracts or insurance contracts. Okay.
Okay, thank you, Cyrille. I think that was the end of your discussion on force majeure and how the courts in KSA consider the force majeure situations. What I think it would be useful now to share with everybody is a bit of a checklist that we've put together, which will support people and provide you with an approach or guidance on how to approach your particular situation. So what we've done here is a little checklist. The first thing, and I might just unmute both speakers so that they are also able to add in any points at this point. But the first thing was to start with what the contract says, and to check the governing law of that contract, as this will affect the different options available to you. If there is a force majeure clause, then you take heed of the force majeure clauses, together with any termination clauses that are in the contracts, to see what circumstances can be relied on to terminate a contract if that is a plausible option. Then there is the circumstances that are actually affecting the performance of the contract and trying to create the causal link. So another particular clause which should be regarded is the notices section, to see who, when and where the notices are to be served and what is to be included in those notices. One of the key things that needs to be checked is whether the performance of the contract is in fact impossible as opposed to difficult, which Richard covered in his slides today. So check what are the steps that can be taken to actually mitigate or minimize the financial harm. And check your insurance coverage. So many of the questions that we have that we'll move on to shortly also relate to the insurance coverages. So that needs to be checked because all the clauses are different. And again, depending on what the governing clauses in those insurance coverages, they may differ. So keep in contact with the other party. This is crucial to the situation we're in at the moment with the corona affecting not just the UAE, but globally, and therefore commercial arrangements worldwide. It is extremely important that we take measures and try to mitigate or to communicate with the other party and explain our situation and obviously understand theirs and try to find a middle ground, because ultimately coronavirus may not be around forever, and I'm sure that most businesses, or would be in the interest of most businesses, to keep those viable relations. So another key consideration and checklist is to consider the hardship relief provided under Article 249 of the Civil Code. And for some contracts, parties are entitled obviously to payment for the work completed. This again is contract by contract basis. So if it is a fitting contract, just to keep in mind that they operate a little differently and they allow for suspension of performance of the contracts. Okay, so before we go on to, I suppose, how we can help, what we might do is, because I can see some of the numbers have dropped off, is just address some of the questions that have been raised by participants. So I urge you not to leave so that you can have the benefit of the answers to the questions. And at the end of the slides and discussion, we will also be offering to all the participants today legal support, which I'd love to speak to you about, and I'm sure that perhaps you may want to avail. So if I go back to the first question, and I'll open the floor now to Richard and Cyrille as well. The first question we've received is, whether COVID-19 qualifies as a force majeure under UAE law, and for how long the status of force majeure will last. So what is the cutoff event, if there is, to use force majeure as a, to use COVID-19 as a force majeure under the legal contract. So I believe we've already covered that, Richard, in your slide.
Yeah.
If you want to,
I think, let me just repeat it. It's up to the court as to whether or not the particular circumstance or event is force majeure. Certainly, the cutoff date can be no later than the 11th of March and may well be before then, depending on which country you're in. When is the cutoff date for the UAE? Well, that's a matter for the court to decide. Certainly no later than 11th March, may well be before, depending on what the circumstances were like then. Thank you.
Great. Okay, so
question. The position is the same in Saudi. Yes, it would be up to the court to decide whether there is an event of force majeure, making it more difficult or impossible for the parties to fulfill their contractual obligations. As for the starting date, I would guess that would be the 19th of March, for example, which is the date on which King Salman made his televised speech and declaring the state of emergency to the Saudi people.
Great, thank you, Cyrille. So the next question we have is, if we have given our tender and the tender is awarded, however, due to the contract situation, we are not in a position to take up the contract, will it qualify for force majeure? We have already given a tender bond. In such case, will the client encash the tender bond?
Right. It depends on what this, it depends on the reason why, depends on if the reason why you cannot perform is due to the coronavirus. If it is, I would say it is force majeure. And in those circumstances, you can, I'm going to assume, as we're talking about a bond, we may be talking about some sort of construction here. In those circumstances, it would be very unreasonable for the other party to cash the bond if you weren't able to comply because of force majeure. If it is a contract of construction, it's covered probably by FIDIC, and in virtually all the FIDIC contracts, you might want to go straight away to a dispute arbitration board, a DAB. First of all, contract the engineer, contact the engineer is obviously going to be well aware, but put a formal notice into the engineer. If the engineer won't stop the bond being cashed, go straight to a DAB procedure. Again, if you'd like to write to us and explain that in a bit more detail, we may be able to give some more specific help.
Great.
Because I'm trying to guess on what's going on there. Yeah.
I think we should make a disclaimer when we are answering these. We don't have the background. We certainly don't have the documents or the contracts which give us enough knowledge to be able to answer accurately. So this is not legal advice without having all the documents, but we certainly hope that we can give you an idea and some guidance on how to perhaps think about some of the answers to these questions. So we'll just move on to the next question. Given the scale of the pandemic, can force majeure be implied despite the clause not being in the contract? I believe we've answered this as well, but it all depends on what the governing law clause of the contract is. So here it says, whilst not UAE or KSA, we have customers in India claiming force majeure due to a government lockdown, making it impossible to operate as normal.
Well, my feeling is if you're dealing with India, you're probably dealing with the laws of India, which is a common law jurisdiction. And the problem is, in a common law jurisdiction, force majeure is not a common law concept. If you don't actually write a force majeure clause into a common law contract, there's no force majeure. So if the governing law is the law of India, and you haven't written in the force majeure clause, you may not, you're probably unlikely to be able to claim relief under it. But again, I don't know all the circumstances, so I'm just, speculating as to what might be going on. Yeah.
Great. So we have another question from a retail and fashion industry. The mall was closed, so therefore there are no sales. They have to pay suppliers, but they cannot. The mall is cashing out the rent checks and is not willing to cooperate. What would we advise?
Well, this is again a case for negotiation. This is, if they want any customers after force majeure finishes in 3 or 4 months, they're going to have to give you some sort of support, because if you're not going to take the lease, certainly nobody else is going to take it. You're not in quite the weak position you think. I'm going to give you some advice. Go and see somebody who can negotiate on your behalf. Quite frankly, go and see a lawyer who can send them a letter setting out the situation and trying to mediate some sort of solution suitable for both parties.
Great.
Thank you, Suraya.
So I believe we've got a few more questions only, and then we can discuss how we might be able to help. But so this is a construction-related contract. It's a FIDIC contract. There are no clear force majeure provisions for an epidemic case. The governments are taking additional measures which are impacting the conditions of work from the point of view of costs and related time. I trust these can be accommodated as additional costs due to the change of legislation or as any other FIDIC clause.
I reckon the person who's asked that question has got it right. I reckon that because it comes under the force majeure provisions of FIDIC because it's legislative changes. It's government intervention, which is one of the provisions in a FIDIC contract allowing you to claim force majeure. And obviously, whether it's a green contract or a red book contract or a pink book contract, first thing to do is to get straight onto the engineer to tell him of the variation and the amount that you're going to claim.
Great. Thank you, Richard. So a few more questions. It's a fashion showroom and finishes on May 15. They paid their last check on March 15. But right after the situation, they could not use the space due to the situation, and they could not establish work remotely due to the nature of the fashion production house. They couldn't move out and find a new place, also for the same reason. So taking into the consideration that's a global situation, they'd like to extend the stay into the showroom until situations get better in a reasonable time to move. What would our advice be? Again, similar.
Cyrille, do you want to take that one? Suraya?
Yeah, no worries. So
You can handle that. We've given this advice. It's negotiate, isn't it?
yes, exactly. This is a case of negotiation. So similar to what you covered earlier, Richard.
Yeah.
It's really tricky with the leases. Most of the malls understand, most of the places, I don't know where this showroom is, whether it's a mall or not, but again, depending on the situation, it would come down to a case of negotiation, as most people do understand the situation. So what I want to do at this point is, again, just reiterate that we would like to help you. We would love to give you specific and accurate answers, but as we don't have all the circumstances and all the documents, all the real estate contracts, we're not able to see and determine the exact circumstances under which you might be able to claim, or to give you the position, I guess, for you to be in the strongest position to negotiate. So please do reach out to us after this, because we do want to give you as much information and to answer your questions accurately. There are some other questions here. So another question is that unless the government claims it to be a state of emergency, regardless of the World Health Organization claiming it as a pandemic, the current circumstance in the UAE may not be upheld as a force majeure. I can take this one again if you like, but yes, exactly. So unless the government in the UAE says specifically this is a pandemic and it considers it to be in UAE and therefore considers it to be a case majeure, it will be case by case, and we won't really know whether in many contracts COVID-19 is considered that until it is taken up by the courts and we understand what their perspective and how they are going to apply. Would you agree with me, Richard and Cyrille?
I would, and I want to bring in a corollary as well. Don't forget, just because it's force majeure doesn't automatically release you from your obligations. It's got to be, why weren't you able to perform? There may be many things that for COVID-19 doesn't affect, including the ability to write out a check and pay your debts.
Exactly.
So if somebody's already you've provided goods or services to somebody, and they're now saying, oh, it's force majeure, we can't pay, you want to know why.
That's
Sorry,
right.
we perform the goods, we perform the services, why can't we have your check? How is COVID-19 preventing you from writing a check out?
Yeah, correct.
Yeah.
Okay. So we have some employment questions here as well. We could answer those, but I'd like to leave those for our next webinar, where we will talk about employment. So I think they were all the questions that we've had so far. I hope that we've answered those to your satisfaction. But of course, as I was saying earlier, please reach out to us so that we can provide you with specific advice on your specific inquiries. Some of the ways that we can help, and it sounds to me like many companies may need a health check just to review their legal contracts, for us to go through and see what the legal implications could be that they haven't factored in already. If you've got cross-jurisdictional matters, we can support you to manage those, liaise with the regulatory authorities on your behalf, negotiate favorable terms for you. So if you are negotiating a term of a lease, or if your rental payment is due, or whether you should be given a sort of relief from that, for how many months. If you are in a contractual dispute, again, we can handle those for you. So what we're doing today, just to support businesses during the corona, and we know that for many, they will now have budget constraints. What we'd like to offer everybody is packages through our Corona Crisis Support Hub, which allows you to have a number of hours monthly where you can avail our support and our legal knowledge, and provide you with specific and tailored advice to your inquiries. So I encourage everybody to go to the website, Legal Circle Corona Crisis Support Hub, and please avail some of those packages so that we can answer specifically your questions. Another thing is, many of you have asked if we will share the slides. Yes, we will, to provide you with that extra support as well. So for those of you who have remained with us, thank you very much. We do have many webinars coming up. We may even run this one again because it was extremely popular. On the 6th of April, we have a law, finance and innovation together with Grant Thornton, where we navigate the coronavirus and the impact on your business and explore ways to increase and ensure your chance of survival. We have another webinar on employment law considerations on the 8th of April. We also have a manager's and director's liability, and we have a number of others as well. So we will email you after this the presentation slides together with our upcoming seminars. I can see that a few people have raised their hands, so I will try to take those questions. Just going to try to work out how to, I think just on the blow here, to take those. I can't see how to actually open this up to the floor for people to ask their questions. If you just bear with me. What I encourage you to do is to send us over your questions, and we will get back to you and answer those by email. So the emails are for you on the next slide, info@Legal Circle. You can contact us or on our LinkedIn page. Follow us please on our LinkedIn page. Unfortunately, we won't be able to answer all of the questions or take the people that have raised today. But Richard and Cyrille, are there any last comments that you wanted to make on any other topics or any other questions that were asked?
I have one, and it's this. Whenever you're in a bad problem, don't hide away. We said something a few weeks ago, and Suraya, you're the one who raised this. This coronavirus situation is causing a great deal of panic and fear. And Suraya, you know how we deal with fear. I'm going to let you take this on. Contact us. We can help you.
That's right. That's right. Many people have made inquiries, and I think many people are now, exactly as Richard said, panicking about what their business will look like. What are the trajectories? How long is COVID going to stay around? Will it affect our business? Yes, it will affect business, but it doesn't mean it necessarily needs to destroy business or destroy companies. We think there are ways that you can remain viable, whether that is looking at restructuring your companies, whether that is getting the right advice to answer your questions, to negotiate particular circumstances that you're in, because for every problem there is definitely a solution. And so this is what we really encourage you to have a mindset, which is to face everything and rise rather than face everything and run. Thank you very much for those that have provided very positive feedback. We'd love for you to email us and to give us more feedback, and to also tell us if there's anything that you wish to hear more about, because we will keep these webinars ongoing. Hopefully we will create also some podcasts, but we'll have lots of videos that we will upload as well in the coming weeks. So we look forward to you joining us in our upcoming webinars. Please do reach out to us. If there's anything we can do to help, we'd love to during these times. I think that's all for today, and we look forward to seeing you at the next ones. Thank you very much, everybody. Thank you, Richard and Cyrille.
You're welcome. Goodbye, everyone.
Bye.